Hello, I am Anesia Baptiste, political leader of the Democratic Republican Party of St. Vincent and the Grenadines, the DRP SVG, with a special message for you Vincentians. As leader of the DRP, I wish to condemn and urge immediate removal of Clause 16 of the Cybercrime Bill 2016, which was introduced into SVG's House of Parliament in June this year. The bill, which is currently before a select committee of the House, is expected to be debated in Parliament at its next sitting on August 4th, and I believe it will pass if the select committee's work is completed by that time. I am an invitee to select committee meetings on the bill. I have highlighted my concerns on national radio programs and repeatedly at select committee meetings about various aspects of the bill, and particularly about Clause 16 as it is currently constituted. With my experience as a former senator of the House of Parliament and as a holder of a Bachelor of Laws degree with honours from the University of London, I pointed out that Clause 16 of the bill has two main features which are dangerous to God-given and constitutionally guaranteed human freedoms of expression, speech, the press, and information. You see, Clause 16 creates an offense called harassment utilizing electronic means of communication. And this offense basically criminalizes electronic criminal libel and communication, which constitutes cyberbullying according to its definition in the bill. What are these and what are the problems with them? Let's look first at criminal libel. When I say criminal libel, I am speaking about a situation where if a person publishes information that is false about another person, they publish lies, that's libel. It is defamatory, or it defames the reputation of the other person. In our law, you can sue such a person in a civil court. You can ask for apologies, and you can also sue for damages, usually in the form of fines. But sadly, also in our law, libel is criminalized in the criminal code, meaning you can actually go to jail for wrong speech. Let's talk about this. Criminal libel is an antiquated and draconian law which uses the disproportionate punishment of imprisonment for publishing wrong speech or speech that is false. While it is true that criminal libel has been on our criminal code for many years, one must understand that it has fallen into disuse because such laws have a chilling effect on free speech and have been used by tyrants in old times to punish political opponents and dissenters. As a result, international press freedom agencies such as the International Press Institute, the IPI, out of Vienna, Austria, Reporters Without Borders, as well as even legal bodies such as the Parliamentary Assembly of the Council of Europe in their resolution 1577 of 2007. All these have long encouraged nation states throughout Europe and the Caribbean to decriminalize libel in the interest of the protection of the people's freedom of speech. You see, libel or defamation is already proportionately addressed in a civil, not a criminal court. Because to criminalize a man's speech, giving a man a criminal record, sending a man to jail for words, it puts the right to free speech itself in jeopardy. Yes, my dear people, it sends a message of fear and self-censorship among journalists and regular citizens, and this is destructive to society because society needs to hold government accountable by using free speech and free expression. And when you have a law such as criminal libel, which drives fear into the hearts of many and causes them to want to be afraid to speak because they know they can go to jail if they are caught with certain speech. When you have such a law, it has a chilling effect on free speech. Therefore, criminal libel laws are simply not justifiable, reasonable, or even necessary in modern societies which practice democratic methods. You see, no law which proposes to create a just limitation on free speech must turn out to have the effect of destroying the freedom of speech itself. That is disproportionate. Now, Grenada became the first Caribbean country to take the forward move of decriminalizing libel in 2012. Jamaica and Antigua followed also. Trinidad and Tobago decriminalized it partially in 2014. However, in some of these same countries, cybercrime and electronic crime laws are a threat to the progressive move of decriminalizing libel. And such is the case today in St. Vincent and the Grenadines, because in our Cybercrime Bill 2016, one of the things it proposes to do in Clause 16 is to bring criminal libel into cybercrimes. In other words, it makes provision for electronic criminal libel, and it would cause the revival of criminal libel uses. In terms of using the law of criminal libel that is on the criminal code, it will cause its revival in our society by bringing it over into cybercrime legislation. Now take note of this interesting fact. The UK, the United Kingdom, from whom we inherited criminal libel on our criminal code so long ago, has since decriminalized it in 2009 because of its threat to free speech and free press. I call upon our government to repeal the criminal libel provision on our books and to refrain from passing electronic criminal libel in the Cybercrime Bill 2016. Now let's look at the second issue about Clause 16, which threatens free speech. In Clause 16, there's also a provision. It also creates the offense of cyberbullying under Clause 16, which deals with harassment utilizing means of electronic communication. I want to read it for you. It says, and I quote, "A person who uses a computer system to cyberbully intentionally or recklessly another person commits an offense." So if you use a computer, a laptop, a tablet, your Android phone, any kind of a computer device or electronic device to send data which constitutes cyberbullying another person intentionally or recklessly, you commit a criminal offense. But interestingly, what do they mean by cyberbullying? Let me read also that part for you. It says, for the purpose of this section, cyberbully means to use a computer system repeatedly or continuously to convey information which causes a fear, intimidation, humiliation, distress, or other harm to another person, or B, which causes detriment to another person's health, emotional well-being, self-esteem, or reputation. I want you to consider some of the words that are used to describe or to define cyberbullying. Words like if your communication causes fear, intimidation, detriment to health, self-esteem, humiliation. My dear people, not only are these words vague, subjective, and lacking legal certainty, and therefore not meeting the standard requirement of properly drafted law, but their broadness also means that the section can give rise to abuse by prosecuting and judicial authorities. And the very truth you speak can be criminalized just because someone claims that by you publishing it, publishing it via a computer system, you cause them to feel humiliated, distressed, and all the other words that were used. Let's take an example. A Christian preacher of the gospel of Jesus Christ publicly rebukes the immorality in the public life of a politician in society, using cyberspace for his preaching or even radio programs that are broadcasted in cyberspace. If the politician feels that his speech repeatedly published in his programmings, rebuking the politician about his sins and his immoral behavior in society, if the politician feels that that speech is harassing him because it's causing him distress, he can bring a claim in the court. He can bring a claim before the police, and if he gets a charge, bring it before the court against the preacher. Even though the preacher may have simply been telling him the truth that God says in his word. Yes, my dear people, think about John the Baptist and King Herod in the gospel account. John the Baptist preached that King Herod was an adulterer because he had taken his brother's wife. And his brother's wife was upset. She wanted King Herod to deal with John the Baptist. He didn't at first because he feared the people who loved John the Baptist as a favorite prophet. But a last opportunity came when he promised his wife's daughter anything that she wanted because of how well she had danced in his party. And when she asked her mother what to ask for, she said, ask for John the Baptist's head, which she did. And the king had John the Baptist, the prophet of God, beheaded for simply telling him the truth, which offended him and his wife. Did you hear that? It is a similar thing that clause 16, subsection 1 and 5 would be doing. It would be bringing into law what you call the principle, okay? The principle of what you call the King Herod principle, the Herod principle being brought into law. This is very bad for society. This is very bad for the exercise of the right to religious liberty, freedom of conscience to preach what God says you should preach, because somebody is offended or feels distressed or harassed, and that you can go to jail and get a criminal record for it. It is atrocious, it is ludicrous, it is vexing, it is a backward provision in law, and that is why I call for it to be removed and not passed in the Cybercrime Bill 2016. You have to understand that if it is passed into law, not only can persons be criminalized with heavy fines of up to 200,000 Eastern Caribbean dollars maximum under this section, and or go to jail for a maximum of 5 years or both, according to the law, that's the penalty. But also, the decision to convict will be left up to the arbitrary feelings of a magistrate or judge in the absence of legal clarity on the terms which define the offense. Even if the matter never reaches the court, the police and prosecution through whom complaints will be made can be flooded with time-wasting, nonsensical claims which they will arbitrarily assess because of the lack of clarity in the law. Even children who use cyberspace also, and who may use it to bully each other, they can be caught too under the law. You see, the question we have to ask ourselves is this: is bullying criminal if the words do not constitute credible threat of violence to person or property? It should not be. Even the truth published repeatedly may be seen by some as bullying. While it is true that it's unpleasant to be harassed and bullied, the solution is not to criminalize this behavior, but to encourage social interventions among the children and the youth, using their school environment and interventions with parents in counseling and other measures to teach, for example, responsible use of cyberspace, strengthen tolerance, and other civil reactions to bullying. Otherwise, what we will see here is that schoolyard bullying conducted online will cause children to be criminalized under Clause 16 of this Cybercrime Bill 2016 if it is passed. Clause 16's criminalization of cyberbullying will legalize thin-skinnedness among the people of this country. Let me just read for you something that a sheriff had to say about why he discourages the criminalization of bullying among children online. This is Sheriff Grady Judd in Florida. He was quoted in an article called "Criminalizing Cyberbullying Can Ruin More Lives Than It'll Save" by Mike Riggs. This is what the sheriff said, and I quote, "I think law enforcement doesn't need to be involved in bullying. We don't need to make criminals out of kids doing what I call early stage bullying. That's not good. We should be the last ones that are called. I can tell you this, the first line of defense is parents. Parents need to pay attention. They need to quit being their child's best friend and be their child's best parent. That's what they need to do. So it starts at home. What I would like to see is a civil process, and we will have to think through this together, whereby a school system can say, I understand you are bullying and you have used this device. Okay, we've got this anger management school. We've got this anti-bully school. And by the way, we get to hold your device until you've completed the school." End of quote. This is the words of the sheriff. He's saying, let the school administration deal with cyberbullying. We don't have to involve the criminal justice system for that. And in the article, the author concluded by saying, and I quote him also, "Preventing cyberbullying is important, but so is finding more and better ways to mediate disputes between children without involving the criminal justice system." End quote. I believe that if the publication online constitutes credible threats against a person's life, credible threats, of violence against a person's property, that is already in the criminal code. That is a reasonable limitation of speech. Criminalize that. If a person threatens and shows that they have intention to carry out the threat against a person's life or against their property, that is fair. But words which do not constitute criminal behavior, words which simply cause somebody to feel humiliated or embarrassed or intimidated, whatever that may mean, because a person could lie and say, you have distressed me by your words. A person could have vendetta against another person and say, I'm going to bring this claim against you because your words have caused me detriment to my self-esteem, whatever that means. To criminalize such words because of the effects somebody claims it has on them is dangerous to free speech. Clause 16's criminalization of cyberbullying will legalize thin-skinnedness, and this will breed more thin-skinnedness and discord in the population. People who would have usually overlooked and ignored hurtful words will now be encouraged to harbor them in their minds, and they will rush to engage the police and the courts for revenge. A thin-skinned society, rather than a mature one, is what will result, breeding a people who are intolerant, contentious, and full of confusion-making over words that are not credibly criminal. Words published on Twitter, shared on Facebook, WhatsApp, etc. I am horrified to think that in discussion in select committee of our country's parliament, people could use such foolish reasoning to limit the God-given free speech of the people. It is shameful to see, for example, the lack of interest in ensuring that the draft has legal certainty, preferring instead to say, oh, well, let's leave that matter of interpretation up to the evidence in the court. I am horrified to see the insanity in drafting, emphasizing what seems like the need to have revenge and carry out vendetta, seemingly ready to hunt down those who have wronged you on Facebook or on radio, for example. And I am equally horrified to see that there is absolute emphasis on ensuring the state can prosecute rather than ensuring that the law is used as a shield to protect the rights and freedoms of the people, and must only be used as a sword in a proportionate way against credible wrongs. Elected and appointed parliamentarians must understand that people do not put them into office to violate their rights and freedoms with heavy-handedness, but to protect those rights and freedoms is their sacred duty. Not to protect their interest with a political leader, but to protect the inalienable rights and freedoms of the people is their mandate. For if you sit complicit in the making of bad laws against the people's God-given rights, you shall have to answer to the great legislator of the universe, God himself. In addition, you do not sit down to make law to satisfy the hurt feelings of your family members who are thin-skinned, because we live in a free SVG, not an oligarchy. Fellow Vincentians, I say these things with passion and care and concern for you. You need to take up the Cybercrime Bill 2016 and study the provisions. There is so much more that can be said, including the fact that in this bill, the government proposes to make the court's jurisdiction so wide that even if you are outside of St. Vincent and the Grenadines, and even if you are not a citizen of St. Vincent and the Grenadines, and you publish things over cyberspace, including on social media like Facebook, which constitute cyberbullying according to the vague and overreaching definition that I shared with you earlier, if you are even outside of the country, and if you are even not a citizen, you can be caught. These extreme provisions will hurt freedoms, will hurt free speech, will hurt freedom of the press, will hurt freedom of conscience, because people use their private domain freedoms such as conscience, thought, belief, opinion, choice. They use them in their freedom of expression and speech. They use the press like Facebook and other social online press to express what is in the hidden part of their minds. So when you interfere with free speech unjustly with such laws, you interfere with the private domain freedoms of the man. Freedoms which God gave to us when he made us, freedoms with which we are created and endowed by our Creator. And so, my dear people, I urge upon you to join with me. Study this bill quickly because time is late. They intend to pass it soon in the next sitting of Parliament on August 4th if they don't delay. And you need to call upon your government, as I do, condemn Clause 16 and call upon them to remove it from the Cybercrime Bill 2016, which, though it may have good portions, also has bad portions for the rights and freedoms of all of the people. May God bless you. May you be alert if you want to contact me. My number is 528-1015. That's 528-1015, and we can have further discussion. God bless you and thank you. Bye-bye.